Okay, looks like we're about at 5 o'clock. You all ready there at in the planning office?
Yes, sir, we are.
Okay, let's go ahead and get started then. Good evening, ladies and gentlemen. At this time, I'd like to call our special Planning Commission meeting to address short-term rentals in the city of Auburn to order. Reminder, if you please mute your microphones as we start. Amber, can you give us a roll call?
Sure. Wendy Birmingham.
Here.
Robin Bridges.
Here.
Phil Chancellor.
Here.
Jana Jager.
Here.
Matt Lazenby.
Here.
Marcus Marshall.
Here.
Warren McCord.
Here.
Nonette Reese.
Here.
Bob Reichenbach.
Here.
Okay, before we start, I'd like to just say a few things as we get going with this this meeting, and just kind of tell you what we're going to do here. The commission's going to be presented with a single agenda item addressing the proposed Auburn City Ordinance for short-term rentals, and the planning department will present that. That is, the city representative for this item is Miss Katie Robinson. She's the acting city planner, and she's going to summarize the proposal and answer any specific questions from the commission. Once we're ready to have the public hearing for this, I will open the public hearing, and this is going to be your opportunity to address the commission about the agenda item. We all want everybody to be heard, but there's going to be quite a few people that would like to speak tonight, and that's fine. We'd like you to try and keep your comments succinct, limit your time to talk to 5 minutes. And if you do want to basically kind of reaffirm what somebody has already said before, please make that point, but we don't necessarily, unless you have something different to say about that issue, please allow everybody a good time to speak. And after everyone has spoken, I will close the public hearing. Once the public hearing is closed, Ms. Robinson will have an opportunity. We'll answer any questions that we need to address after the public hearing, and then we'll open the floor to the commissioners for a motion to approve or disapprove, have a discussion and a vote. The commission's charge is to vote based on state and local laws, the city's comprehensive plan, and for the general good of the community. With that, I would like to turn it over to the city representative, Ms. Robinson, if you will go ahead.
Yes, sir. Thank you very much. So as everyone is aware, tonight's special meeting is regarding short-term rentals. And in the staff report that I gave you guys, I went through the history of from where we started to where we are today. So about the year 2013, we started seeing an increasing number of short-term rental activity on multiple websites online, and there's like mass mailings that went out to residents within the city of Auburn saying that they could rent their home and make a few extra dollars during football season. So as expected, residents in the single family neighborhood started calling and were concerned with this possibility of doing so. So after a few weeks, months of receiving those complaints and concerns from the citizens, it was kind of a decided routine that we would classify short-term rentals as anything that was rented less than 180 days a year, and that they would be allowed in zones that allowed up to 5 unrelated individuals. And they would be having to remit the lodging tax to revenue office. So that's how we handled that for a while. And the way that it was enforced was the same way that we enforced unrelated occupancy. And those two enforcement procedures were done the same, but the outcome of those were very different. It was very difficult and very challenging for a violation to be found when investigating short-term rentals, typically because those occurred over the weekend and because they were only rented, a few days at a time. So it was hard for us to document any possible violation. So around the year of 2017, the city staff formed an internal working group that was comprised of the finance department, planning, codes enforcement, the city attorney's office, the office of the city manager, and revenue and planning. And it was discussed at that time, how the items that we wanted to see included in an ordinance to have that regulatory framework of a short-term rental. And then we were directed to draft an ordinance that could be presented to the public. So in spring of 18, we had that first draft and had your first work session, believe it or not, almost 3 years ago. So in May of 2018, that was presented to you guys, and I believe we've had some new commissioners come on since that time, so not everybody may have been as familiar when this came back last year to you guys. So you guys knew at that time that what an undertaking this would be and realized that would be the first of many meetings and many chances to offer public input. After Mayor Anders was elected, I believe in August, he shortly after formed the short-term rental task force. And that task force was comprised of individuals from the Planning Commission, the City Council, and 3 citizens. And they met, they had 2 public work sessions and where they gathered comments based on the original draft that was presented to you guys back in 2018. And they were able to provide comments based on that. And the feedback that we got from that meeting was that the original draft was too permissive or too restrictive, I'm sorry, and thought that it should be more permissive and to allow more areas of the city to allow short-term rentals. So that led to the second public meeting from the short-term rental task force. And after those changes were presented, the next feedback that was received was that it was allowing too much. So at the final works or the next to last work session in August, feedback was gathered and there was a pretty good idea of what the task force was recommending. And Forrest Cotton, the previous planning director, drafted up the proposal and confirmed with them at an October work session that was strictly the short-term rental task force, and made sure that all of those recommendations that were given were included in that proposal. So in December of that year of 2019, the Planning Commission started their work sessions with that last draft that was presented. And from that time until your last work session, which was in October, you guys reviewed and made recommendations. We would revise and bring those back to you, and here we are today. And all in all, there have been 6 drafts that were done. And of course, through that time, benchmarking is something that we always do. Always look to our peer communities that possibly have these same regulations in place. And a lot of what we have taken and included into ours has come from Charlottesville, Virginia. But we did look at all of these other communities. And depending on the outcome of tonight's meeting, if there are substantial changes that you guys would like to see made to what has been recommended, then it may have to be re-advertised for a later city council meeting. Currently, we have it slated for February 16th, which if all in all is hardly any changes need to be made, then we will move forward to the 16th, but that may or may not change. You go to the next slide. So the two types of short-term rentals that have been created are homestays and short-term non-primary rentals. And a lot of this depends on the definition of family. And those districts are not included in either type of short-term rental. And we included the definition of family to add the NRD district west of Donahue, as well as the CRDW west of Donahue. Those same districts on the east side of North Donahue can allow up to 5 unrelated occupants. Next slide, please. 3 other definitions were also included, one being homestay, which is a home occupation that has to be owner occupied. And owner occupied meaning is their permanent residence. And on the next slide, I'll go back. If you see the next slide, permanent residence is occupancy of a dwelling by the same individual for a period of more than 180 consecutive days. That's their permanent domicile. That's where they live majority of the time. Going back to the previous slide, you'll see we also included residential occupancy. We use that term quite often to describe the definition of family, as well as up to 5 unrelated individuals. So we just added a definition to help with that. Transient occupancy was actually added to these drafts during the 4th draft. And this is something that I'd like to come back to. I don't know that this definition is needed anymore, since there have been 2 subsequent changes to the proposal where I don't think that this definition is needed any longer, but we'll address that later. The next slide, I mentioned permanent residence. And then the second type of short-term rental is short-term non-primary rental. And that is a dwelling that you're able to lease where it does not have to be owner occupied. It's not a permanent residence of the homeowner. However, they can only lease that property to one party for 30 consecutive days or less. Go ahead. So then we get into the actual regulations of homestay. And I have a cheat sheet on the very last slide that we'll go through as a recap. But just to let you all hear it, homestays are within the home occupation section of the zoning ordinance. And they are allowed in all of the zoning districts that allow up to 5 unrelated individuals. So neighborhood conservation, development district housing, limited development district, and the LLRD are not included. Those are all single family neighborhoods or zones, and those are not included in this proposal, as well as the NRD and the CRDW on the west side of Donahue. No more than 6 overnight guests are allowed per day. The homeowner must be present no fewer than 120 days at the residence. And I have this highlighted as well, as I'd like to come back to this section. Food cannot be prepared for a homestay, and a zoning certificate or a home occupation license is required yearly, and that's valid from January 1 to December 31st. And it says during this period, it has to be their permanent residence, i.e. they're required to be there 180 days. And then the last section just discusses the 3 strikes or you're out. You get 3 substantiated complaints and your homestay can be revoked. And this will, if it is revoked, it will be at the time that it's revoked as well as the following year. So those are home occupations. The table of permitted use table classifies short-term non-primary rental as a special residential use, and they are allowed by right in all of the zones that allow up to 5 unrelated occupants. So all of the urban neighborhoods, the medium density residential, neighborhood redevelopment, east of Donahue, RDD, rural, CDD, the CRD zones, and then the CRDW is the only one that's a little bit different, and that's only east of North Donahue. The SCCD, I think that accidentally snuck in there somehow because residential uses are not allowed in the South College Corridor District, and I don't believe that had been in there previously. So somehow that snuck its way in, and I believe that was just a typo. And let's see. The special development standards that have been created for this include that they are limited to 240 calendar days of operation. Their time period starts January 1 and ends December 31st, and a zoning certificate is required yearly. And the same penalty that requires, or that falls in line with homestays also applies to short-term rental. If there are substantiated complaints, then the license can be revoked. And I believe that's the long and short of the actual amendments that will be included in the zoning ordinance. And so this is a map showing all of the areas. The green is showing the areas that allows short-term rentals, both homestays and short-term non-primary. The gray is all of the single-family neighborhoods and or university property, industrial zone property. I believe that's it. And then the next one is just a comparison between the short-term non-primary rental and the homestays. You'll see that the zoning districts are the same in both. They're prohibited in the same zones. One is just classified as a special residential use in which you don't have to live in. And then the other, you have to have only in conjunction with a home occupation license, which has to be your permanent residence. Each require a yearly license. There's no limitation of rental days per calendar year for a homestay, as long as the homeowner is present at least 120 days of that calendar year. However, short-term non-primary rentals are limited to 240 days per calendar year. There's no limitation on the number of guests for a short-term non-primary. However, you are limited to 6 overnight guests for homestays. So I can go back to some things that I found in reviewing all of this. If you'd like to do that now, or if you want to ask any questions now, we can do that.
Let's go ahead and roll on. Go ahead and continue.
Okay. So transient occupancy was put into the 4th draft as an attempt to reconcile the notion of allowing transient occupancy in zones limited to just family. But since the short-term non-primary rentals and the homestays are allowed in all zones that allow up to 5 unrelated occupants, I don't believe that this is even necessary anymore. That was when we were having kind of a multi-tiered approach to the different classifications, which also goes to the C of homestays. Let's see, homestays, subsection C. So here it says that a homestay may operate no more than 120 days per licensing year when the residence is not owner occupied. And then it goes on to list the zones that it's allowed in. So those zoning districts are the only zones that homestays are allowed in. So I don't know why we are including those same zoning districts when before some zones were limited to 60 days, some zones were limited to 120. It originally started out as 30 days, and I think that might have just been left in there as the versions kept changing. So if we choose to leave this, or you guys choose to leave this, I just recommend deleting those zones, because subsection A already notes the zones that they're allowed in. And because homestays have to be owner occupied, I think rephrasing that to say the homestay may operate no more than 120 days per licensing year when the homeowner is not present, instead of owner occupied, that just, to me, it adds a little confusion, because we've already said that it does have to be owner occupied, when I think the intent is the homeowner has to be present at least 120 days that the home is being rented. And then I already mentioned the SCCD, that might have inadvertently snuck in there somehow.
And you just proposed just removing that outright because it doesn't apply. It's non-applicable.
I agree.
Okay.
Yes.
Okay. Anything else on that? Well, how about for the planning commission? If you have any questions on basically for clarification, if you don't mind, to start with, if you have any of those kind of questions, let's ask Ms. Robinson, and then we'll have a public hearing.
Can we just go back to the slide that has both of them lined up and has all the information on one sheet?
There you go.
Okay, thanks.
And what's the significance of having that in? I know SCCD is, I got that, but what about the one down the bottom right? What's the significance of having that highlighted in red?
That was just pointing out, just to remind you guys about the subsection C of homestays, just how it could be phrased differently. Instead of being owner occupied for 120 days, maybe say that 120 days that the homeowner is present. during the rental activity.
Bill,
Katie, can we, sorry, can we, I don't remember us talking about limiting the homestays to 6 overnight guests. Is there, I mean, I don't necessarily need to know the history, but did we talk about that? And is there a reason we would limit the number of guests if somebody lives, if the owner is there versus when they're not?
So I believe that was one of the first iterations of the, yeah, that was included in the December 2019 draft. But that also was when, well, the zoning districts in which they were allowed were all 15. So the urban core, the urban neighborhoods, all of the single family zoning districts. So it was all up to 5 and family that was included during this iteration.
If I'm remembering correctly, that's why we had decided that no more than 6, because that version included the NC and some of those family neighborhood zones. So it's probably not relevant anymore.
well,
Yeah, let me, Marcus may be able to back me up here. My recollection is that is a carryover from when homestays were being widely considered to be in some of the one unaccompanied, one unrelated areas. And then, of course, that is not before us now. The one unrelateds are not available for homestays in the current proposal. But I think the 6 is a carryover from when we were, when the task force was concerned about the impact on a homestay in a single family community. So perhaps it would be no limitation if the owner was there.
well, this is Warren. To me, if the logic, and this is part of my logic in terms of allowing it in those zones that allow up to 5 people to reside in the same dwelling, then that's the justification for allowing these types of uses up to 6. I would consider that somewhat compatible. Whereas if we start going up to unlimited numbers, then to me that causes me to pause and wonder, maybe we need to put maybe we shouldn't allow it in this many zones where there are residences. But when residences allow up to 5, I can say to those people, well, you're allowed in your neighborhood to have up to 5 unrelated people. Therefore, I can justify allowing short-term rentals with up to 6 people.
Well, we have it, it's under the homestay though, currently.
Homestay, same way.
Well, then I think
So would we
need
not
to be,
want it to be
we should be
consistent?
uniform here. We should either, it should be 6 in both or
Okay.
a limitation of 6 in both or no limitation in either, I would think.
Okay, well, I go with 6 in both, yes.
Okay.
I think that would maybe presuppose that we were able to control. I mean, yes, we can potentially control them for short-term rentals, but if I have a house with 5 college students, there are plenty of times when they have guests and there are more than 5 people in the house. So I'm not sure that I love the idea of trying to limit the number of people somebody can rent to in that same situation.
Phil, do we
Yes,
need to
ma'am.
open the public hearing before we get into too much deliberation?
That's
on
why I'm
this?
asking for clarifications. So if you can get clarifications, we're going down the trail, but
Yeah, we seem to be discussing
Then
it.
let's open it.
Yeah.
Well, I guess,
My question has been clarified.
Okay.
Thank you.
go ahead, Marcus.
yeah, I have one potential clarification, but it may get too far into the weeds, so I don't want to do that necessarily. So I don't know when to, but I do notice that the part about you can essentially lose your license if you have some kind of disturbance that entails a substantiated complaint. What is the planning director? How do they determine what is substantiated? As far as, is it just about if a neighbor, calls public safety, or do they email the planning director, or maybe that hasn't been thought out yet, but that did kind of jump out at me.
Katie, I'll jump into the enforcement side.
Thank you.
It's for the general public. Megan Mcgowan, Crouch, Assistant City Manager, soon to be City Manager, February 1. So we'll be addressing this when it gets to the City Council as well. But at the end of the day, substantiated complaints, if a nuisance or a noise complaint is called into the police, those are documented into a system. We have cross database access, and we'll be pulling those pretty constantly and matching them up against the database of whoever is licensed to operate a homestay and dealing with it that way. But substantiated complaint doesn't mean that there's 3 cars lawfully parked in the driveway and there's an issue. The planning director will be hardly involved in the enforcement of this. This falls to the inspection services department that handles our general city code enforcement. And we'll be dealing with the enforcement side as we proceed. But substantiated means it's been documented by a city staff member that there was a legitimate issue, not just because somebody thinks they're one. So that means could be the police if it's after hours, or it could be a staff member from our inspection services who's been called out. There'll be a way for citizens to complain, and we will go out and inspect or observe what's going on. And if it's substantiated, somebody will be notified that they have a strike and what the consequences thereof are. But I don't want to take away from the fact that if there's a noise complaint, not only will it be a strike, but the police are going to ask that the noise stop. And if the noise does not stop and they come back, there will be further consequences under the nuisance side of what the city does and further enforcement there. So it's not just running a short-term rental. Every weekend, our police respond to noise complaints and do a great job of it. And for our citizens watching, it's important to understand that if you call and complain through our communications, we will follow up. They are required to follow up on everyone, and they do. So I think that's important to note that the city takes that very seriously.
So are we saying that enforcement's going to be primarily driven by complaints?
No, we're not. That's one aspect on the strikes and you're out. But I mean, there's things, we have overflowing garbage that happens. Our own folks out picking up the garbage see that. The neighbors may not complain. Our staff could be out. We're not looking for things, but there's, just to get this out there. And I know you really do. We can discuss further on the other side of the public hearing, but we do have and have long subscribed to a database service that lets us know who is renting, and we will, if an ordinance gets in place and is established and recommended by you and onto the city council, we'll be notifying those folks of where they stand in terms of whatever is decided and how they can get into compliance, or that they need to stop doing their short-term rental activity if it's not allowed in certain areas, and we will follow up accordingly. There's a whole other aspect, and that comes to the city council side of it, because there'll have to be some resources we'll have to put toward that. But that's something we're willing to do if that's what the council wants to do.
Okay, thank you. So there are any other further clarifying questions? Okay, well, let's go ahead and open the public hearing. So I'm going to open the public hearing at this time. And the way I want to proceed with this is you have a way of raising your hand electronically. I see at least one person that's done that already. So if you want to speak, I'll kind of go down the list as the hands appear, and you'll have 5 minutes to speak once I unlock your microphone here. So the first one is going to be Mr. William Albrook. All you have to do is unmute your microphone and then you can speak.
Hey, Phil, thank you for letting me speak.
Can you give us your name and address, please, everybody?
William Albrook, and the property I lived in was at 1905 Wrights Mill Road. I no longer own that piece of property. I now live at 3000 Lee Road 10, lot 79. But what I wanted to bring to your attention, and Phil, I believe you've been to my house before, so you know the property I'm talking about.
Mhm.
But the stating of only 6 people staying in a house, when I have a 6-bedroom house, that is going to leave you open for a lot of people saying, well, why is that the case? You're only going to have 6 people in a rural area with that could sleep 25 if you had that many bedrooms. I think that's leaving the city open to legal suits or problems in the future. And that's really all I had to say.
Okay. All right. Well, thank you. Let's see. So the next one is Mr. David Tidwell. Go ahead and unmute your mic and you can speak.
Good evening, Mr. Chancellor. Thank you for taking I just have 2 questions.
Can I get your address, please, for the record?
David Tidwell. I live at 1147 South Ridge Court, Auburn 36832.
Thank you.
And I have 2 questions. I think they might be quickly answered. The first is that now that we have a clearer understanding of what the proposed policy is from a balance of permissive to restrictive use here, will neighborhoods that desire to rezone from one where homestay and short-term non-primary rentals are permitted by right to one where it is prohibited, applying the family rule through a rezoning action, would we be able to do that and complete that before this new policy takes place once it's approved by the city council?
I'd like to address the questions after the public hearing. So we've taken that down. The short answer is there's a process. Whether we can do it that fast is remain to be seen. But what's your second question?
It's will the public be able to view via an online method which homes in their neighborhood have an approved certificate? Meaning, will that be made public, or how would, if we were interested to know who in our neighborhood has city approval via certificate to have a homestay or short term non-primary rental, will that be public information to see?
Okay, it's a good question. We'll have that addressed too.
Thank you, sir. Appreciate it.
Okay, thank you. Okay, let's see here. The next person with their hand up is Susan. Go ahead and unmute and give us your name and address, please.
Hey, Susan Bolt, 1188 East University Drive. I've got several different questions. I don't know if I should just mention them and maybe y'all can circle back to them.
Well, that's how we're gonna proceed. So if you give us the questions, we'll make sure we answer them all.
Okay, I'm curious how many people on the planning commission have stayed in a short-term rental. I wanted to mention that my house is currently in an NC neighborhood, but I think there's some misunderstanding, and I don't understand what the goal is of the regulation, because it seems somewhat arbitrary. I'm in an NC, which is neighborhood conservation, yet I have the East University thoroughfare coming right by my house, so that I don't think would add to neighborhood conservation. And then I've just had a big, huge apartment complex pretty much in the backyard. So I have some questions about what exactly is being accomplished by trying to rule that out, mainly because a lot of my guests are extended family. Because I have a larger house, it's a 5-bedroom house, I can host extended family, which is the majority of the stays that I do, which are for like weddings, graduations, seminars that are being held either at the university or surrounding areas. I've had like swing dance groups. So a lot of my stays are multi-generational, and I feel like there's a misunderstanding that most of the short-term stays are football enthusiasts who are loud, and that's not been my experience. And so I'm asking y'all to reconsider the NC excluding the NC designation because it just seems so arbitrary. I would suggest that perhaps we focus on those short-term hosts who allow problems to happen. For example, I monitor noise. I limit how many people can come to my house because I don't want my house wrecked and I don't want my neighbors adversely affected. And I understand not everybody does that, but I just don't want to see overregulation to adversely affect those people like myself who are trying to be good stewards, yet enjoy being a short-term rental host. So I'm asking for us to reconsider. Like I say, it seems arbitrary to discount the NC designation. And I would also like to mention that Austin, Texas has already gone through this situation where they tried to limit short-term rentals in certain areas, and it went all the way to the state Supreme Court. And they ruled that as long as the house is being used for a like use, that it would be allowed. And that I just thought that I would mention that because there is some history about this already being litigated that might work to give y'all some guidance as well so that you don't have to circle back. There might be some guidance there. Again, I just want to mention as far as the 6 limit, I have a 5-bedroom house, so that doesn't seem reasonable. But my main purpose is I'd like to know how many have stayed in a homestay and to explain why eliminating the NC is not an arbitrary decision. Thank you.
Okay, thank you. Okay, the next one is Nick Waters. Go ahead and unmute your microphone. You can speak.
Hi there. Can you hear me all right now?
Loud and clear. Please give us your name and address.
All right. My name is Nick Waters. I live at 128 Kimberly Drive. So to me, the differentiation between a homestay and a short-term non-primary rental, as things stand today, doesn't make a whole lot of sense if the zoning is effectively the same. It's not clear to me why somebody would even go the route of having a homestay versus having a short-term non-primary rental where they could decide not to be there in the first place. I agree with some of the comments Susan made about excluding NC zones. I think that homestays really make sense in single-family neighborhoods. That's, going back to the beginnings of Airbnb. The purpose of it was to allow somebody to rent a bedroom or rent a basement or rent part of their house. And so the people that are doing that are people that live in the house and want to make some extra income. And those people are primarily going to be in single family neighborhoods. I understand the concern that some have raised previously, that you don't necessarily want to live next door to a house that is just a rental house. Nobody lives there. It's got a keypad on the door and different people are in there every week. I see that as being the short-term non-primary rental, but the homestay is not that. In a homestay situation, you'd still have neighbors, you'd still know your neighbors. And if your guests were loud, ultimately they'd be irritating the neighbors you have to live next door to day in and day out. So I don't think eliminating NC zones or any other family designated zones is giving homestays a fair shake. And I feel like as things stand now, very few people are going to even avail themselves of trying to operate a homestay in the first place. That's all I've got to say.
Okay. Thank you, sir. All right. The next person in line is Donna Goodled. Go ahead and unmute your mic and you can speak. And give us your name and address.
Hi, my name is Donna Goodlett, 1766 Creekwood Trail, Auburn.
Okay, thank you.
I speak as a member of, and the majority for our Creekwood Development Homeowners Association. I would like to say that you should have already received a petition.
We did.
Stating the following: we are designated rural and wish to be removed from the areas where short-term home rentals are allowed in this proposal. It is not only inconsistent with the unique nature of our development and neighborhood, it is directly at odds to our restricted covenants. So I'm not sure, but it looks like that is something maybe the city or the planning commission has not considered. This is a direct violation in our covenants, and not just our neighborhood, but others as well. I would also like to add and remind, if we go back a little bit in history, just a few years ago, the city of Auburn, along with the Creekwood Development and Ashton Park, were in court for 2 years pertaining to these exact issues. And I do not think that any of us want to repeat that again.
Okay, is that it?
That is it.
Okay.
Short and sweet.
Thank you, ma'am. Appreciate that.
Thank you.
Okay. All right, the next person on the list is Mr. Bruno Ulrich. So if you can unmute your mic now and tell us what you think. Give us your name and address.
Hello, my name is Bruno Ulrich. I reside at 1518 Stewart Circle, Auburn. First and foremost, I want to extend my appreciation and my surprise at how well Miss Katie Robinson was able to present herself and to know this complex issue. I think she did an outstanding job in presenting the topic.
Well, thank you. I sure appreciate that.
Secondly, as I was a member of the Mayor's Task Force on Short-Term Rentals, so I'm familiar with the topic. And I think I've expressed this before to others. Regarding the short-term non-primary rentals being limited to 240 days of operation, I don't know what the developers, owners, investors are going to do with the remaining 120 days. And I've suggested before that perhaps you want to consider extending that or revising that 240 to 365 days. Next item is I've talked with many people in MZ zoning districts, and everyone that I have talked with, and know that I haven't not talked to everyone, but everyone that I have talked with is opposed to having homestays or short-term rentals in the NC zone. Now, when I've talked with Forrest before he departed, he and I had an extensive private conversation together. And throughout the period that the short-term rental task force met and other times, it was felt that the ordinance as presented is a reasonable ordinance, and then let's give this a shot before we proceed any further with expanding it or otherwise revising it. In other words, a sunset provision may be worthwhile to include, so that we're forced to review it, say, in 2 years or plus or minus thereabouts. Those are my comments.
Okay, thanks, sir. Appreciate that. All right, let's see here. The next person in line is Mr. William Neely. Go ahead and unmute your mic and you can speak. Give us your name and address.
Can you hear me now?
Yeah, I can hear you now.
Okay. All right. So my name is Charles Neely. I live at 415 Hare, H-A-R-E Avenue, right here in the old part of town. I've been here for about 50 years. It is an NC zone, and we really enjoy it. It's populated primarily by families set up that way. We did have, I should tell you right now, the unfortunate case of someone coming in and buying a house, converting it to basically a short-term rental. Person's from California and seldom here. The consequences were just disastrous. The only thing that closed it down a little bit was the pandemic, so no one could travel. But it has been a major problem, and I can see it would continue to be a major problem if that activity continued here. And I think that's a chance you have with anything. Now, this nice lady who was on previously, Susan, does a nice job, no doubt, of monitoring her house. But she's not everybody. And so I think that people who go into a neighborhood zone and buy property at really residential prices and start a business, which costs a lot more money to start in most business districts, are not doing the right thing. It's just not right to allow that. You shouldn't go in and make a cheap bargain on taxing your neighbors. The situation should be relieved a little bit with the new map, assuming you hold to it. There is a factor. I couldn't believe it, but I measured the areas, and the area of the green zone that is allowed by right zone in the new map is approximately 30 times what it was in the previous map. So there'll be plenty of space out there for people to go and buy property and start their homestay business or short-term rental business or whatever they want to do without breaking the bank and without having to compete with each other, and above all, without necessarily having to fight with their neighbors and impinge on their neighbors and make everybody else unhappy. So I do think that we've done very well. I think the NC district ought to be protected. That's what people bought those homes for. They bought them for a neighborhood, bought them for the families. They didn't buy them to support someone else's business, I think.
Okay, does that conclude your comments?
Yes, sir. That concludes my comments.
Okay, thanks, sir. Okay, next one is Missy Clemmer. Go ahead and unmute your mic and we'll be able to hear you.
All right, this is Clayton Clemmer. My wife actually just stepped away. We were both.
Okay. Name and address, please.
419 Cary Drive. And I'm kind of echoing a couple of the earlier people as far as, I mean, we've done short-term stays across this nation. And one thing that they all had in common was that they were all in residential areas close to the activity that we were wanting to attend, whether it had been a wedding or a graduation or a football game or any other type of sporting event, or in some cases, just to hang out in a town just to see what it was like. One of the other gentlemen was discussing the residential areas, which our neighborhood is zoned for, and they just seem to be way too restrictive. We're saying in the other zones that the person has to live there or be at that house 180 days, where you have families such as myself, we'll probably be here 300 of those days, if not more. Our house is set up in a way to where in some of the houses that we had rented, there was actually a portion of the house where the owners actually never left, but they had a little secondary house or a basement or whatnot that they were renting out, and that's what we did. It seems like we're letting some of the crazy examples of a short-term stay, which there are some, unfortunately, those things do happen. But we're letting them seem to really dictate the restrictions throughout the whole process, not just in those houses that were deemed allowable to have the short-term stay, but especially in the residential areas where you're talking two people or whatnot, when those are the ones who, in many cases, hey, we're just trying to make a little bit of extra money to supplement something because, hey, we're gone for the weekend or we have another part of the house, not just those that are investors who are coming in to buy a property in order to turn that. It seems like we're hurting our current residents in order to keep future investors out. And I guess the main question that I have is, how was the restrictions determined for these residential areas? Where was the concern? How was that determined? Because it seems as though we're letting some small examples dictate those restrictions to the homeowners. And that's the end of it. Thank you.
Thank you, sir. Okay. All right. Carolyn Smith, please. You're next. All you got to do is unmute your microphone, give us your name and address.
Hello, can you hear me now?
We can hear you now.
Oh, good, thank you. I'm Carolyn Smith and my home is at 420 Hare Avenue. And it is my second home. I bought it in order to visit my family. I visit many times a year, several to 4 or 5 times, staying weeks at a time. This last year was an exception, of course, with the pandemic. I want to stand with Susan Bolt and her comments. I have a lovely home. I bought it, like I said, to visit with my family and even potentially retire there in several years. I do rent it to families, multi-generational families that visit their children that go to Auburn, maybe a wedding, maybe graduation, and yes, sometimes game day. But those rentals account for maybe 30 or maybe 40 nights a year, in which most of the rest of the time I'm either there or nobody's there at all. I take very good care of my home. It's a lovely home in a lovely neighborhood. And I want the board, the Planning Commission, please to reconsider the NC exclusion. I think it's unfair that people like myself and Susan Bolt are being excluded when we take good care of our home, expect people who come to stay in our home to take good care of our home. I have to admit that early on in my rental history, since I've owned it 3-4 years now, there was some learning curves that I had to get through, but now I'm very fortunate to have families that care about my home. I have a 5-star rating. I have excellent reviews, and I don't want to lose my home. I count on that supplementary income to help make my payments. And I suppose that's all I have to say. I don't want to lose my home. I love Auburn, and I'd love to be able to stay there. Thank you.
Okay, thank you. Okay, next is Mr. Bill Caskey. Go ahead and unmute your microphone and we will be able to hear you.
Hey, my name is Bill Caskey. I live at 521 East Samford. It is an NC designated neighborhood. First, I would like to thank in advance the Planning Commission for hopefully bringing this festering issue to a conclusion. I have 2 asks. First, protect NC neighborhoods. These are residential family neighborhoods. I want to know who my neighbors are. I do not want itinerant renters passing through the house next door or the house down the street in what is supposed to be a family neighborhood. The negatives of trash, noise, parking issues, safety for kids because you don't know who the people are. I'm opposed to allowing any rentals in NC neighborhoods. My second ask is that once this ordinance ordinance is put in place that there be no wind out period. People knew when they bought in these neighborhoods that are prohibited that it was against the rules. So to give them permission to have a year before they can no longer rent it, I think is unfair. It'd be akin to driving 60 in a 30 zone when you get pulled over. Say, well, give me a year and I'll start driving 30 a year from now. So I just say protect the residential family neighborhoods and no wind out period. Thank you.
Thank you, sir. Okay. The next person is Beverly Ficken. Sorry if I hammered your name there. Just go ahead.
Can you hear me now?
I can hear you now. You don't sound like.
I had the same situation as the other gentleman. My wife stepped away, but I'm happy to step in here.
Okay.
And
give us your name and address.
Oh, yes, sir. So sorry. 126 Norwood. Live around the corner from the Clemmers and on Cary. Live in an NC neighborhood. And I'd like to stand with those folks that would like some consideration for the NC opportunity. I think that there's probably a happy medium or a compromise to where the owner would have to be here in order to accommodate guests. I think that would be a fair and would alleviate a lot of the concerns I'm hearing about turning it over to somebody who you don't know and they're here and the police could get called, but the owners are there. That's one potential compromise. Perhaps put those folks on an opportunity list that says, hey, 3 strikes and you're out. I think I heard that referenced earlier. I think there's a way to compromise and allow people that have the space and the opportunity and frankly have the gift of hospitality that want to extend their home and invite people to the community and show them the community and help people that need to be here to do that without just a blanket NC exclusion. You can't do it. You can't ever do it. So I'd like to see some accommodation rather than just a blanket, you can't have it because you're an NC accommodation. So I stand with those folks that say, yes, there's some way forward for us to do this rather than no, there's got to be no way. We don't ever want to have anybody next to us that we don't know.
Okay. Is that it?
Yes, sir.
Okay, thank you.
Real quickly, that's assuming I'm understanding this to be that the way I'm reading your notes, if you're an NC designation, you have no allowance, no days, in no way will you be able to.
That's the proposal. That's the proposal.
Great. So then my comments stand. Yes, thank you.
Okay, thanks, sir. Okay, Mr. John Braswell. Go ahead. Might be having some technical difficulties here. His microphone's on, but can't hear. Your microphone's on, but we can't hear you. Mr. Braswell, are you there? It's possible that you do not have the volume turned up on your microphone. If you go down to the bottom left of your screen, there's a mute, unmute. Well, there's a little menu there that will give you audio settings and you can turn up that microphone. Well, We're not hearing them. I see your hand raised. I know you're out there and want to say something. Let's see.
If he wants to send us a chat, maybe we can assist him that way.
Or we can go back to and Phil, if you'd like to.
Say that again.
If you'd like to move on to the next person, maybe, and just give him the opportunity to.
He is the last person.
Can you hear me now?
Okay.
Yeah, there you are. There you are. We hear you.
Okay, sorry about that.
Okay.
I always thought I was technically proficient. Obviously not.
That's okay. It's the world we're in now, right?
Okay, so I've got a couple.
Give your address, please.
Okay, John Braswell, 2250 Arlington Court, in Ashton Lakes. So we don't rent our house, any portion thereof, nor do we have any plans to do so. But I had a couple of questions and then some comments. So the first question is, since we live in a 4-bedroom house, we have an apartment above the garage. And my first question is if my wife and I wanted to help, like a single mother that had 3 kids, to come and live in our house for a little while to perhaps get her back on her feet, would that be breaking that rule of having more than 2 people, unrelated people, living in a house? And my question is, that's the first part of it. The second part is there an exception for that? The second part is for people who have expressed the interest to continue to rent a portion of their home in these NC districts. Is there some type of a grandfather clause? I think you've outlined, and here's my comments. I think you've outlined a procedure to this 3 strikes and you're out type of procedure. I think that the toothpaste is kind of out of the tube, and to try to restrict anybody from renting their home or a portion thereof is kind of opening a can of worms, a can of litigation worms on one side or the other. But at any rate, you do have a procedure outlined to regulate any kind of complaints. There's already laws on the books or ordinances on the books for noise, garbage. You've outlined some of those here, parking, et cetera, et cetera. And so, I think the people that I know that rent their homes out are like the 2 or 3 people that have talked about renting their homes out in NC districts. They care about their homes. They care about their neighbors. I don't think they, would allow or generally allow their homes to be trashed and their neighbors to be disturbed. So I think there are some procedures to allow people who would like to, especially in this time of COVID, with the financial constraints that people find themselves in, to try to restrict people that have done this in the past. So those are my 2 questions and those are my comments, and thank you very much.
Okay, thank you, sir. We will address those. Okay, we did have a couple more people pop up here. Let's see. Mr. Chip Townsend is next.
Can you hear me now?
We can hear you loud and clear. Oop, I just muted you. Sorry about that. Try it again. You have to take your, wait a minute, I just dropped you. Let me get you back, Chip. Sorry about that. Okay, go ahead now. You should be able to unmute.
Right. Can you hear me?
Gotcha.
Okay. My name is Chip Townsend. I live at 516 South Gay Street. I won't take 5 minutes. I'll take a few seconds and just tell you that I very much appreciate the ordinance as it's presently written with regard to NC zoning. NC zoning is designed for the quiet enjoyment of single family residents. No matter how you cut it, short-term rentals are a commercial purpose. And I won't repeat things that have been said, just say thank you all very much for the ordinance as it stands now, and we support it, as do any neighbor I've spoken to about it. So thank you for your time.
I appreciate it, sir. The next one is Julie Mcgowan. Go ahead.
Yes, Julie Mcgowan. I live at 2526 Waterford Road in Auburn. I have a short-term non-primary rental that is in the permitted districts that are listed, that I'll continue operating as that. But I did want to address the comments y'all were asking about the 5 unrelated zoning. One, thank you for including all of the 5 unrelated zones in this list, because previous lists didn't have those added. So I'm glad you added the other couple other ones back in. And the 5 unrelated, I have several times when I've rented my house, which is a 3-bedroom, 3-bath house, to 6 to 8 people. But usually these are family groups. Occasionally it's family plus a couple of friends. But why would I not be able to just simply say 5 unrelated? Why couldn't I rent it to a family with 8 people or 9 people if they've got a couple of kids that want to crash on a couch downstairs? So rather than saying it's limited to 6 guests, could we not just continue with the zoning of the maximum, the guests could only have 5 unrelated people in their party? Can we define it that way? My second question actually mirrors something that Bruno Ulrich said, and that's about the 240-day limit. Mine stays rented about half the year, so the 240 days really doesn't bother me. But I also don't see why, if I wanted to rent it more, it really would make a difference of 6 of one, half a dozen of another, as far as why I can't get the full use out of the full year. And the reviewing of all of this in about 2 years for a sunset provision on it, I think is an awesome idea, because maybe there's room at that point to come up with some sort of way to let some of these people that are in the NC zone or other zones test the waters, if you will. But yeah, so those were kind of my only things. And thank you to all of you guys for sticking with all this and getting it done.
Thank you very much. Appreciate that. Okay, Josh Poole.
Hi, can you hear me?
Yes, sir.
Hi, my name is Josh Poole. I live at 334 Hickory Woods Drive in Auburn. I appreciate you guys taking the time for this public input. I just wanted to echo a lot of the other earlier commenters and for my full support of short-term rentals, both short-term and non-primary rentals and homestays. I think a fair compromise would be to allow these in all zones, but maybe restrict it to that being your primary residence in lieu of investor properties. I think a lot of the fear comes from maybe a fundamental lack of understanding of what Airbnbs are. I think I agree with a lot of the earlier commenters that I feel some of the ones making the rules may not fully understand or Airbnbs or have stayed in them. My wife and I, we travel a lot, and we've stayed in Airbnbs literally all over the world, all through Europe, all through the United States. And we've always had a pleasant experience. And what I found is that Airbnbs typically are nicer than properties that they're adjacent to, because a lot of times this is someone's primary residence. So they have pride in it, but also they're trying to rent it out. And so you want it to look as nice as possible. And I think people that don't want Airbnbs in their neighborhood may have a fear of neighborhood degradation, or that their neighborhood is being hoteled out per se. But like I said, I think with short-term rentals, people take more pride in the property and will have, it'll stay a nicer property. But a lot of these neighborhoods allow for long stay leases. And some people argue that you don't get to know your neighbor, but if it's the person's primary residence, then what's it matter if they have someone come stay in their house, a few weekends a year, or even if it's a few dozen weekends a year. But it's a lower risk, I feel, than being stuck with a neighbor that's leased there for a year that is maybe not a good leaser, or they don't take good care of the property. And so I just don't see what the problem is in having, it's your property. And if you want to host people and you're not being a nuisance to your neighbors, then I don't see what the issue is in any of these zones, even in NC. And what's the difference in having someone stay in your house for a few nights that may be strangers to your neighbors versus another set of neighbors who's always having people over, either watching any kind of sports games or any kind of events. Like if they're always having friends over, I don't see what the difference is in having someone stay at your house for, a few nights or game days or conferences or seminars or anything like that. So I just think it would be nice to have the option. My wife and I recently just bought our first home, and with the intention of renting out one of our spare bedrooms occasionally on Airbnb. And this isn't something, it's not looking at a second income. It's just, we have extra space and we wouldn't mind making some money off of it. And so that's pretty much all I really had to say is I think all homes should be allowed to do the short-term rentals as long as it's respectful to your neighbors. And if outside developers wanted to, per se, hotel neighborhoods, it would have already been done. I think that threat is not realistic or feasible because Airbnb has been around for a number of years. And I think if there was money in that, it would have already been done. But I think a fair compromise is to keep it your private residence, your primary residence, and maybe ban investors or developers from doing this. And I think that pretty much sums it up. Thank you.
All right, thanks, sir. Jamie Anderson.
Hello, this is Jamie Anderson. I live at 527 Charles Avenue in Cary Woods. And I just wanted to say thank you to the task force and the Planning Commission for all the work that they've done and to open this evening for public input. I've attended most of the task force hearings, if you will, where they solicited public input. And there was a lot of discussion regarding whom people perceive to be the typical renter of an SDR or a homestay. And it was unanimously very negative in terms of the thought process that most people are here in Auburn to, be attending games and become unruly and disturb neighbors. I've been a host on Airbnb for a year now. And we typically rent to people who are moving to the neighborhood and need a short-term stay to find a permanent home. We rent to people who are bringing their families here, their children, for sporting events, tournaments at the university that they host. We host people who are coming for alumni reunions or coming to weddings, or they are just coming to visit and tour the area because Auburn is a really great community. And faculty and graduate students who come to interview. There are a lot of reasons to visit Auburn that really don't have anything to do with some of these scenarios that tend to be more alarming to people. And as a homestay operator, my husband and I are always here when there's someone in our home. We have guidelines that are very clearly posted, and we expect people to adhere to them. We carefully screen our guests, not only for our safety, to assure that they're not going to disturb our neighbors. And we take careful consideration of that for those reasons, as do most hosts. It's not in their best interest to have someone come to their home that's going to be unruly, that's not going to adhere to rules, that is going to disturb other people. In terms of property values, we didn't purchase our home with the intention of being Airbnb hosts, but we have space available, and we have always enjoyed Airbnbs or VRBOs when we travel. And we like those experiences because it allows us to have a more authentic travel experience. We feel safer, we feel more integrated in the community, and can have a better experience. And so we want to offer that to other people. And we invest those funds back into our home to maintain it and to upkeep the property value and to make it attractive as a rental. And you'll find that anyone who operates and is successful in these marketplaces will do the same thing. It is counterproductive to allow your guests to disturb your neighbors. It's counterproductive to rent to people who would destroy property. And it's counterproductive to not vet your guests thoroughly for your own safety as well as your neighbors. And I think that we perhaps haven't had a good representation of people who are performing guest stays or homestays for the general public to understand that. There's also a misperception that people who operate on Airbnb aren't necessarily paying taxes to the city, and that is not the case. We pay taxes through our rentals through Airbnb, and I can't vouch for the other platforms, but I would expect that they have done the registration with Alabama and the city and the county to make sure that they're providing that sales tax to the city. And thank you once again for the opportunity to provide public input.
Okay, thank you, ma'am. All right, anybody else? Anybody else? Going. Okay, I'm going to close the public hearing at this time. And what I'd like to do is go through my rather lengthy list of questions and ask the staff to give us some feedback on some of these things. Okay, one of the first questions is regarding rezoning. One of the neighbors that was on Southridge Road, Mr. Tidwell, was interested. I basically said, yeah, there's a process to rezone, but could he do it? How fast can that sort of thing happen? So can you clue us in on that, in case they were looking to rezone their neighborhood before this proposal went to the city council?
Yeah, so you guys may recall a few months ago, Ashton Park, actually that might have been almost a year ago, that Ashton Park had petitioned Ashton Lakes, had petitioned their neighborhood over a few months period, and finally got a majority of their residents to agree to have their neighborhood that was zoned CDD, allowing up to 5 unrelated, to rezone their property to DDH. So after
DDH was no more than what, 2 unrelated, right?
That's correct. So typically how the process would work is the neighborhood would petition their neighbors. And if we got a majority of the neighborhood that wanted to move forward with rezoning to a district that does not allow up to 5 unrelated, then we would proceed to you guys with that proposal and move forward to city council.
Okay, so that would take at least canvassing the neighborhood to get a certain amount of people to agree is going to take some time.
Yeah.
So
the Ashton Lake process was at least a year, honestly, that we had worked with them.
Okay, so in this particular case, if they wanted to get, this is something that even if we approve this and after the fact, we approve it in terms of, family's going to be no more than 2 unrelated. They happen to be in a 5 unrelated. Mm-hmm. Later on down the path, they can actually try to get it rezoned and then fall into this category where it would be not allowed if we go ahead and do this. So it's a matter of you don't have the time to do it right away, I guess is what it boils down to.
Yes.
Okay, so that, but there are other ways to approach it later on, depending on how we vote here. Public release of certificates of rental. what's up
I'll
with
handle that. I'll handle that one.
Okay.
While business licenses are a matter of public record, when we get past that in terms of they're remitting taxes, other things, that is not a matter of public record. So it is likely that somebody can inquire through the city to gain knowledge about who has a license. It isn't typical that the city would publish such a map. We also don't want to create safety issues, but it's a matter of public record as to who's licensed, and that would be provided upon request.
Okay.
But something we would thoroughly vet with our legal counsel about, how much of that information. But yes, whether or not somebody has a license at a specific address could be answered for a citizen pretty quickly.
Okay. Yeah. That's a pretty easy thing to do. Kind of walk into the city offices to the business where they issue business license. They should be able to take care of it. Okay.
There's a form online. They could just fill it out.
Oh, okay.
Email it in. It's that simple.
Okay. How many, this is a poll of the Planning Commission, how many have stayed in a short-term rental? 1, 2,
I have.
3, 4, 5.
I'm not sure that's relevant.
I know.
Say,
Just want to know. Okay, but there you go. Wanted to, whether it's relevant or not. Some have, some haven't. Okay, let's see. We were getting, one of the questions had to do with some confusion between what's the difference between a homestay and a short-term rental. Short-term non-residents, now I've lost the term. Can you help me out there, Katie?
Sure, short-term non-primary rental.
There you go. Versus homestay.
Right, so
clarify?
Essentially now, the only difference is a homeowner must be present at least 120 days for a homestay, and they're limited to 6 overnight guests. They can rent 365 days a year as long as they're there 120 days. Whereas the short-term non-primary has no limitation on guests, but they're only limited to 240 days. So really it's just the time frame. The zones are the same. One requires a zoning certificate, the other requires a home occupation. The enforcement would be the same. So we've pretty much gone back to the very first draft that was presented in 2018.
Regarding the Creekwood Trail area, and they're talking, they have an HOA there. I know the HOA, the HOA has to be dealt with if you're violating those covenants. That's not a city issue. That's a civil matter for the courts.
That's absolutely correct. Yes. We don't enforce covenants and restrictions for neighborhoods, so they may be well within the rights of the zoning ordinance, but may be in violation of their HOA covenants and restrictions. That's strictly a private matter.
Right.
However, I do know the property in which Ms. Goodlett was referring, and that property happens to be split zone between 2 zones, rural and NC. And I'm sure there are others out in the city that are similar. But in that case, the rental occupancy would be limited to the most restrictive family definition. So if a property is split zoned, their allowance as far as a short-term rental goes would be dependent on the most restrictive form of residential occupancy.
Okay, so split zone with NC, assuming these are allowed in NC, it would default to the NC rule.
That's correct.
Okay.
Yep.
Bill, may I ask just a follow-up clarification?
Sure.
So just to be clear, Katie, across the zone, anything that we pass here, it doesn't modify any restrictive covenants that any neighborhood would have. It that because of the civil matter, they could still have a restrictive covenant against these type of things, and it wouldn't. Nothing we do here overturns that. Is that correct?
That is correct.
A number of people asked about this idea of a sunset provision. Well, maybe there's a couple of different ways to look at this, but one of them had to do with asking that once this becomes an ordinance, once the city council, because we're not passing the ordinance here, this is just a proposal for the city council to pass the ordinance, and once they pass the ordinance, basically, if you're in violation, then that's when there will be some enforcement against those people that, even though they've been renting Airbnbs for however long they've been renting them in the zone. So is that an enforcement issue that will be pursued, or how is that going to work, I guess, Ms. Crouch?
Well, I'll speak to that. As I had mentioned earlier, if the council were to adopt something, there will be some sort of short period. I don't want a misunderstanding about long periods of time for people to come into compliance. Staff will have to send out letters to those who need to be licensed and those who we believe are operating in areas that they are not allowed to be operating in. They'll also be told that they're in violation and to stop renting, and we'll deal with that from an enforcement perspective. I also think the sunset provision we don't typically put in our ordinances that was being referred to is something that says that this ordinance ends at a specific time. We do that with like a moratorium ordinance. That's normal because it has to have an end. You can't have a moratorium ordinance forever. I think what this is signaling, if I understood some of the comments correctly, is can this be revisited after a period of time to reevaluate and see if changes need to be made. And I think that comes in many forms. I think that comes in discussions, comments you're getting during citizen surveys, requests from the council, other things that staff is seeing. And I think that comes in many forms. As we get an ordinance out there, if one is ever adopted, that then we will revisit as comments, questions, concerns, or changes necessitate that. So
right, and the public can always change the rule, if you will. I mean, if the ordinance is put into place, there's a process to go and relook at the ordinance.
Correct.
Okay. Let's see. This might be addressed to Ms. Robinson. So another line of questioning had to do with the basic. We made the basic call on where it would be allowed versus where not allowed, having to do with the definition of family in that particular zone. So can you kind of explain that again in terms of the more than five versus, the 5 unrelated versus the 2 unrelated, different definitions of family? Because that's where we drew the line. We didn't this is not arbitrarily and willy-nilly. We looked at the structure of the family unit, if you will, and the ones that had no more than one, unrelated, we're saying no, we're not going to. We propose no, none of this there in those areas. However, in all of the other areas around the city that allowed families of up to 5 unrelated, it was okay. That was the demarcation.
Right. So most of the comments we've heard tonight have been from residents that are either against or for allowing short-term rentals in neighborhood conservation zones. Well, there's other single-family zones that also prohibit this. So we're only proposing to allow them in zones that allow up to 5 unrelated, and prohibited in the neighborhood conservation districts, the DDH districts, limited development district, and the LLRD zoning district.
So for what it's worth, Katie, we were very deliberate about that as we progressed through our different work sessions.
Absolutely.
we
Yeah.
finally came to that conclusion that that was going to be the way that made sense.
Yes.
Hence here we are.
Yeah.
Another question, and this is probably not necessarily, well, might not directly be related to this, but this has to do with the enforcement of and I would suggest the current enforcement of the family with no more than one unrelated person. So we had a gentleman that kind of mentioned the fact of a what if scenario, and if there was an exception. And what it boiled down to is he said, "Hey, I've got extra space. I have a single dad and a kid that I want to help, and I want them to live in that space, and that's more than two unrelated to my family. How does that play out in terms of enforcement? Is that just he can take care of it because he's trying to help people out, or is that if there's a complaint driven thing that says you got too many people in there, give us a little enforcement sort of
So when you're looking at unrelated occupancy from an enforcement standpoint, if you had a family renting to another family, that would be in violation of the family definition, because the husband, unless the husband or wife are related to someone in the family that's being rented to.
Yeah.
But if both of them are unrelated to the occupants, then that's in violation.
Okay.
Phil.
Yes, sir.
This Warren. Let me comment on this NC exclusion that we have. It's not that we're not allowing, I want to emphasize that, we're not allowing homestays and STRs in Auburn. We're only prohibiting them in the small area of Auburn that is designated as a single-family neighborhood. The single-family neighborhoods were not developed arbitrarily. They have been in the ordinance since 1985, when this ordinance was developed. At that time, as we were totally redoing the ordinance and rezoning Auburn in order to accommodate the growth that was beginning to take place, it was obvious that our citizens wanted zones where they can be protected or where you can mitigate the impacts of commercial activity and multi-unit development. And that's where the NC neighborhood came into play. And so those areas were designated as neighborhood conservation areas. DDH and a few other areas also came into that conclusion, mainly because of the density that they allow, but they still carry the same character. The purpose of those zones was so that they could be separated from commercial activities, as I said, and have as a means of mitigating impacts of excessive parking, traffic, hours of operation, lighting, and noise. So Auburn being a community where people come to celebrate marriages, celebrate graduations, athletic events, great performances in our centers, we have concluded collectively throughout this city since 1985 that NC areas are for families. And we try to define the family, and granted, that's maybe not the best definition, but the whole idea is that if we allow, and this is me now talking, but if we allow the short-term rentals and homestays in the single family neighborhoods, we are violating the definition of the single family neighborhood. So that's why we have it. It's not an arbitrary thing we pulled out of a hat. It's not an arbitrary. And by the way, I don't know where they were tonight, but based on what I have been getting, both every time I'm out of the house or my email box has been from those people who want to protect our single family neighborhoods. I'm finished.
Okay, thank you. All right, before I ask, just more open discussion or a motion or something like that, let's deal real quickly with the couple of items that were brought up earlier that we, might want to consider either leaving them as is, because that's what was, proposed in the public announcement, or come to the conclusion that that these just don't make sense anymore. It was part of one of our earlier thoughts about how this should work, and then get rid of it. So can we deal with that real quick? Like, this is one of them right here, the transient occupancy. So Katie, is this something that are you proposing that we just remove this definition from, consideration?
That's my suggestion. Just because it was originally put into a version that is no longer valid.
Any discussion or druthers one way or the other from the commissioners?
Yeah, if we change anything in here, does it change the timeline for this going to council, or have to be reviewed again as a public hearing, or how does that work?
Only if it's a significant change, and I doubt this would be.
Yeah.
In talking with the city attorney, we will review what you do if you act on this tonight. Tomorrow, I think the bigger deal is adding or changing things that weren't advertised. You're advertising that you're discussing these issues tonight in the form that they're in, and if you're removing things in your recommendations, while I can't guarantee it, it is not likely it'll cause a change in advertising or a delay. It's if you add things and decide we're going to add a whole new element to this, that is where it changes, but that's okay too. You need to do and make the recommendations you see fit, and we'll deal with the legal side. If it delays, it would just delay it a couple of weeks to the next council meeting in March. And what we want is the best ordinance out there, from this group moving forward to the council. So do what you wish, and we'll deal with the legal.
So you're saying that if we go ahead and try to remove this, then we're gonna have to re-advertise and kick the can?
No, you're a recommending authority, and so likely removal would not cause the issue. You're just recommending removal of these things,
Okay.
That's how you proceed. It's if you wanted to add a whole new element of something we've not advertised that you're discussing,
that's a problem.
That's where it goes off the rails a lot more.
Okay.
So I had to talk with legal counsel before this meeting to make sure and try to give you guys some direction, and that's where we landed. But we will evaluate tomorrow should you act on this tonight and let you know for sure. But I'm not anticipating, unless you add something major, that'll delay us in advertising.
Thank you very much.
Yeah.
What if we want to consider, can we take these considerations as a package, or should we take them individually?
Take them as a package. Like, aren't they related? There's a couple of them that are just related. One's an administrative sort of thing, the SCCD.
I would recommend as a package, but that's up to you guys how you want to proceed.
Just make sure in your motion you have enough, if you want those things stricken or what have you, that you have enough to say. And really, if you were to choose to eliminate homestays altogether, I mean, that strikes a few things, Katie, doesn't it, that you had suggested with one fell swoop?
It does.
And the occupancy transient would be a separate issue.
Yes.
So the record is clear in your motion if that's what you choose to do.
Okay, so this is one of them. What's the other one that you want to consider besides the zoning SCCD?
Right, removing that altogether. And then just rewording subsection C to say when homeowner is present or when the homeowner is not present instead of is not owner occupied. I believe that causes some confusion in homestays altogether because the homeowner must be present. Well, in order for it to even be considered a homestay, it must be owner occupied at least 180 days for his permanent residence, for that to be considered his permanent residence.
So that can be restated as when the owner, how would you restate that to get it right?
The homestay may operate no more than 120 days per licensing year when the homeowner is not present.
Okay.
And then eliminating the listing of the zones, since those are no different from the zones listed in subsection A. I think originally there was some difference in the number of days and the zones that those numbers corresponded to.
Okay. So reword and eliminate the zoning designations out of that particular paragraph.
Yes. And Amber just pointed out one additional item that is probably a good idea to include. Subsection F, change zoning certificate to home occupation license instead of zoning certificate.
Yeah, it's not.
And in E.
Okay. What was the term you used for that? Home
occupation license.
Occupation license. Okay, is that it?
There was one other thing that was brought to my attention late last week. As far as, go back to the homestays. Subsection E, this would apply for homestays as well as the short-term rentals, non-primary rental. Where the licenses say per calendar year. Let's see, I'm sorry. Not that one, the NF. Where the complaints are received within a calendar year. I think maybe change calendar year to a 12-month period or a 12-month time frame. Because
it needs to be calendar year because the business license runs on the calendar year.
Okay.
Yeah, that's getting into some serious weeds there.
Okay.
Okay. All right.
Perfect. Well, then that's it.
Okay. All right. So, discussion, motion.
I have discussion. Katie, can we go back to the last slide again that it compares them?
Sure.
Okay, so I think Bob may be able to help me out because we were both on the task force. But I kind of think that basically there's no real distinction between the homestay and short-term non-primary rental now, because there was a distinction before. Because at the time, I think the idea was to have maybe homestays allowed in certain districts where the short-term non-primary rental was not allowed and whatnot. But since that has been erased, it seems to me that these should be pretty equivalent, especially when you look at the way this is being interpreted about homeowner presence required during the time of rental activity, no fewer than 120 days per calendar year. If I'm doing my math right, that means that there's 245 days when you don't have to be present. So that's essentially the same thing as the 240 of the short-term non-primary rental.
You're exactly right.
Yeah, I don't think that's a bad thing. I think, and also I just want to say as an aside, listening to some of the people who were, pro a less restrictive ordinance, I just want to say that I think that I guess just speaking for myself or whatever, I don't want to give the impression that we have anything against commerce, or that we have anything against the people who run these type of this type of activity. I kind of get the impression that, there's some kind of an idea that, we think the people who use these or have this type of business or doing something that's bad or immoral or anything like that. So I just want to be on the record to say that I don't have any type of judgment on the people that do this sort of thing. I'm involved in commerce myself, and I think that it's a wonderful and noble thing for someone to take their property and decide to, they want to make an income off of that and whatnot. So that's not an issue at all. But I do reject the idea that this was arbitrary. I think that by making it, this is allowed in family districts, and this is allowed over here where you have 5 unrelated occupants. I think that makes it actually less arbitrary than if you did it the other way. But I do think that these two different categories are just, they're not necessary. And I do think they need to be brought closer together. So for instance, the limit to 6 overnight guests per day, I don't see the purpose of that now that we have it, the way it is now. And again, I understand that if we make these kind of changes, there's going to be, it's going to push it back a little bit. But I think we should discuss things like this because, that there's no reason to rush, right at the goal line. I think we have a very good ordinance here. And I think there's just a few changes that I think we can make to make them, closer together. So for instance, like I said, the six overnight guests, I think we should talk about that. I don't see any reason to limit the number of guests when you're talking about a homestay. And I'd even say just the whole idea that you have to be present. I think the important part of the homestay is that this is your house. I mean, this is your primary residence. The fact that you're in the house, I'm not sure if that matters when you're talking about you've got 245 days where you don't have to be present. I think that's all I had to say. Let me just make sure there wasn't something else really quickly. Also, if we decide to do a sunset provision, I think in most cases, those are actually in the ordinance where you say that the sunset provision, it's 2 years. And then so you go back and look at it again. I'm not saying we necessarily need to do that, but that's my opinion on that. So anyway, I'll shut up for the time.
And I have a quick question too about the difference in the homestay and the short-term non-primary rental. It looks like the licensing is different on those. Is that like a necessary distinction, or we would need to keep those separate? I know
so because the short-term non-primary rental is a special residential use, it is issued a zoning certificate would be issued for this. And you're required to be a permanent resident in a homestay. So you're issued a home occupation to operate that business from your home. So
there's a distinction as far as how they're set up, how they would register with the city.
Correct. Okay. But Marcus he's got a valid point about
the use, I think, is basically the same, but
yes,
other than it's a primary residence versus a secondary residence.
That's right.
Okay.
Yeah, that's probably a good reason to keep them separate too, in my mind.
I think we would have to keep them separate, even if we decide the days of use and things like that could.
Are the same, yeah.
Same.
But does anyone have an opinion on the 6 overnight guests? Like, I understand that there may be a bias as far as not making any substantive changes, but as far as the 6 overnight guests per day, I mean, if you have a 3-bedroom house, then if they're couples, you're at that limit. So.
I mean, I know families that are more than 6 people, I know families that have 6 and 7 children. So I don't have as much of an issue with it as long as there is places for cars to park and beds for people to sleep in. I don't think that's really too much of an issue.
I'm not a fan of that either. I don't really see the point in that, honestly.
What number would we choose then?
I would do just like the short-term, non-primary
Yeah.
rental.
No limitation.
No limitation.
Yeah,
Somebody's
I
house.
wouldn't have a limitation.
So what do you say to those people who can only have up to five unrelated in their home? Is that not, in other words, we're talking about trying to not be arbitrary. That's why I thought we chose the 6, because that was within reason of what we were allowing the other people to do on a long-term basis. I'm not opposed to it necessarily, but I'm just looking for some logic here on what we're doing.
Well, Warren, I do know, and
I think it seems to me it's not.
Hey, hang on. Hey, go ahead, Jana. Hang on.
Well, I mean, I know that the number of guests, my experience in staying in VRBOs in other cities is, the number of guests that are allowed is determined by the owner of the property. So just because we might say that maybe it's 6, 8, 10 or no limit, that doesn't mean that every VRBO will be open to have an unlimited number of guests. That will be determined by the property owner. So if they have a 2-bedroom condo, they may only allow 4 people to stay there. So, I mean, it's very specific to each individual unit. But if someone has a 6-bedroom house, they may
Well, under other
be able to house 12 people.
Like other rental units, we regulate by bedroom or bed. We can do it that way.
For full-time rental, yes, we do, or occupancy.
Yeah, I don't think we're ever
talk about it in terms of occupancy. We're going to talk about that.
Go ahead, Robin.
I don't. Sorry, I never know if you guys can hear me or not out here in the country. I don't think we're ever telling anyone how many guests they can have in their home. That's what we're talking about here. This is a short-term situation. So, we're not ever telling a house full of 5 college students how many guests they can have for the week or the weekend or whatever. They could have 20 people in that house. We're talking about a short-term situation. So I don't think a number, I don't think it's arbitrary. I think it's apples to apples. We've already determined how many people are living in the house in the homestay situation. So how many guests that they have on a temporary basis, I don't think is regulated anywhere in any type of zone or situation. So to me, it's the same thing, if that makes sense.
You're in support of no number then, is that what you're saying?
I am in support of no limitation on the number of guests, yes.
Let me ask the staff a question. Since the public safety regulates the amount of occupants of other commercial activities, do they regulate anything related to hotels, rental properties, that sort of thing?
We just happen to have John Hoare sitting in here on the meeting tonight. If you could repeat your question to John, he may be able to answer.
Well, we're talking about whether we have allow an unlimited number of people in these zones where we allow the homestay short-term rentals. And my question was, is there a public safety limit that you would set, because you do say it is a commercial activity, and even though it's in someone's home, and you regulate the occupancy, safe occupancy of other commercial establishments. Would this be, and you don't inspect these, so is there any problem with public safety in that regard?
It does. There's no way, a single family home, if you have a bedroom, is required to have things like an egress window.
Say that again.
In like a single family home, you have to have egress windows for every bedroom.
Okay.
But we also, people have guests that stay over on their sofas and things of that nature. It's truly hard to enforce where people stay in their private single family homes, as opposed to a hotel. They're not going to be putting people up in their lobbies.
No. Okay.
Warren, I think also just to kind of follow up on that, I mean, because they're both commercial activities, but it's different when we're talking about a space that's open to the public versus your home, because you don't have to get a certificate of occupancy and says only so many people, because it's not a space that's open to the public. These are kind of like guests, people that you're bringing into your home. And so that's why I think it's not the same thing as, like a hotel or a restaurant or something like that, where you have to say, well, you can only have so many people in here at one time. So to me, it's just a little different. And so that's why I think that we're kind of going down a bad road if we're telling people, oh yeah, you can only invite 4 people over this weekend because of XYZ. And
No, I'm not talking about inviting people. We're talking about.
Right. It's a commercial activity. I do agree it's a commercial activity.
I mean, I understand what you're saying, but we're talking about paying guests. That's different.
Right.
Okay.
Well, let me ask a question about those couple of things that we were talking about, striking and all that. Can we do that, or can you as the planning department do that administratively so that we don't have to make it part of the motion here?
No, it should be made part of the motion.
Okay.
So we can send that on to council so they will know what your recommendation is.
All right, then it looks like one thing we have that sounds like a kind of an issue that remains is this, limiting the number in homestays. I suppose we can, we have a motion, we can make that part of it or keep it as it is, or.
That's definitely a possibility. Something that if you guys do choose to remove the 6 overnight guests and allow no limitation for homestays, include that in your motion as well.
Mr. Chairman, so that this doesn't get too convoluted and we don't do what we want to do in the major part because of one issue.
Right.
You give some consideration, and I think you could go quickly if we just took these things individually and make a motion and yay or nay and move on to the next one.
In terms of each of those changes?
Yes, sir.
Okay.
It'd actually be for Robert's rules purposes, you would need to move for approval to bring the business to the table. And then you would move to amend, and you would vote on each of the amendments separately. And then once you're done with that, then you would be voting on it as amended, however you voted the amendments, and that's it.
Okay.
So there may actually be 3.
Yeah, I've got
because of the definitions.
Yeah, I've got 3. I have rewording in section 511.04. I've got a couple of changes in the definition that you just want to change it to home occupation, and then the third one's then there's the removal of the zone SCCD, so that's the third one, and then the fourth one would be us if we want to address that the number of people, so that'd be the fourth one.
That's perfect. So you get your main motion, whatever that is, then vote your amendments, and then you'll go back to the main motion as amended if you amend it. All right.
All right. Anybody want to go for a motion?
Well, to put it on the table, then I would move that the ordinance as advertised be recommended to council for approval.
I will second.
Okay, I have a motion and a second. Now let's talk about those potential amendments. I've kind of written these down. You guys mind if I make a stab at these, since I've got some of these notes here, and you can correct me if I'm wrong. Okay, so there's a couple of amendments I'd like to put forward. So this is a motion to reword. Give us the back a couple slides there. No more. Next one. There we go. So the first amendment that I'd like to make a motion is to remove the definition of transient occupancy from the proposed ordinance.
Seconded amendment.
Okay, and so I have a motion in the second. we'll go ahead and vote on that. So all those in favor say aye.
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 Those opposed say no. Those opposed say no. Okay, that amendment carries. Okay, go another, here we go. The second, motion for a second amendment would be to reword in Article 5, Section 511.04, regulation on home occupations, paragraph C. We're going to remove all of the zoning designations and restate that paragraph as follows. The homestay may operate no more than 120 days per licensing year when the owner is present. Do I have a second?
Second that amendment.
Okay, I have a second. All those in favor say aye.
Aye. Aye.
Okay, all those opposed say no. Is that a yes or a no, Nanette?
Yes.
Okay.
Yes.
All right. That amendment, motion for that amendment carries as well. Two other, so in the same article, same section, paragraph E, the motion for an amendment is change the wording of zoning certificate to homestay license. Is that the right word?
Home occupation license.
Home occupation license.
Second.
Motion and a second. All those in favor say aye.
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 Those opposed say no. Okay, the next one would be same Article 5 for home occupation regulations. This is paragraph F. Change the term zoning certificate for a homestay to home occupation license.
Second.
Motion and a second. All those in favor say aye.
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 Those opposed say no. Motion carries. Let's see, was that? Yeah, this one. So on the Article 4, Table 4-1, General Regulation, Table of Permitted Uses, the motion, a motion for an amendment to remove the zoning designation SCCD.
Yeah.
Motion and a second. All those in favor say aye.
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 Those opposed say no. Okay.
Who seconded that motion?
Nanette.
Thank you.
Okay, so now we have a motion on a proposed ordinance with amendments. And now we want to vote, we want to have a motion to approve the ordinance, the proposed ordinance.
We never tried, this one amendment.
I'm sorry.
Because I can propose an amendment and we can vote to see if it passes or fails. But I would like to make an amendment.
Oh, another amendment. Okay, I got you.
Yeah, I would make a motion for the amendment to
Forgot it.
okay, change the under homestay to redact the limited to 6 overnight guests per day and make it unlimited. So I don't know where in the.
Yeah.
I'll second that.
Okay, I have a motion and a second. So so that effectively, are we eliminating that paragraph B? Is that right?
That's correct.
Okay.
Yes.
Okay, we have a motion and a second. All those in favor say aye.
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 Those opposed say no.
No.
Okay, the motion carries. Now we're back to the ordinance as amended. So now we have to have another motion and a second for that. We're going to do a motion. Looking for a motion.
You do not need another motion because the main motion remains on the table. It's the motion as amended, and that's what you would be voting on.
Okay, so now we have the vote. Okay. Okay, so we have a motion and we have a second. And Amber, can you do a roll call vote, please?
Bridges,
No.
Chancellor,
I didn't hear you say Chancellor.
I did.
Okay, sorry. Yes.
Jaeger,
Yes.
Lazenby,
Yes.
Marshall,
Yes.
McCord,
Yes.
Reese,
No.
Breitenball,
Yes.
Birmingham.
Yes.
Okay, motion as amended carries. Okay, well, that brings us to the end of the meeting. I have no communication under Chairman's communications. Staff, is there any other information that you'd like to present or anything for us?
Well, Maddie Intrican started with us last week, so she is joining us tonight for this meeting.
All right.
She's sitting in the back, if you can see her.
Welcome. We can't see you, but we look forward to seeing you.
So we are happy that she's here.
We are too. All right.
Other than that, that's all we have.
Okay, well, this meeting stands adjourned.
Thank you, everybody.
Thanks a lot.
Thanks, everybody.
Have a good
Thank you.
night. Thanks
Good
for the
job,
work.
Phil.
Thank you.
Very good job, Phil. Very, very good job.
Thank you. I appreciate that. Thanks for everybody's help. All right, take care, you guys. Have a good night.